Justice Kavanaugh?
You just said a minute ago that a lot of this is taken care of on the ground as a practical matter, and I think one of the questions is who takes care of it on the ground. Is it going to be federal judges, or is it the local jurisdictions working with the nonprofits and religious organizations? So I guess following up on the necessity question, given the line drawing problems that we've been going through, if a state has a traditional necessity defense, won't that take care of most of the concerns, if not all, and therefore avoid the need for having to constitutionalize an area and have a federal judge superintend this rather than the local community, which you've emphasized many times, working with the nonprofits and charitable and religious organizations, which is how it works in most places?
Well, I think that the necessity defense, at least traditionally, has required a much stronger sense of urgency and imminence than this. If states had a necessity defense and we knew that it was available in all of these places, but even in Oregon, I think it's a case called Barrett, the court said it's theoretically possible, but there was a remand for factual issues. So we don't know at this point in time whether there is such a defense, and that's really not in the case here. This comes up on an Eighth Amendment challenge without reference to the necessity defense, and frankly without reference to the new Oregon statute, which seems highly instructive in terms of time, manner, and place that jurisdictions grants passed should examine. But I don't think we can. I don't think the court should put this core point about Robinson to one side because of the possibility that in Oregon and maybe no other place, I don't know about, California law of necessity, maybe it would be taken care of. I think at this point in time that is to
Well, usually we think about before constitutionalizing an area or extending a constitutional precedent, you might disagree with that characterization, but before doing that, we usually think about whether state law, local law already achieves those purposes so that the federal courts aren't micromanaging homeless policy, and it's on a daily basis when you work with the homeless. It's a daily issue. How many people are going to show up that day at the food bank? How many people are going to show up that day at the shelter? So it's not like this is a once-a-year thing.
Yeah, no, for the people actually dealing with it day to day, that is certainly true. The city, the law enforcement, the city liaisons, the nonprofits, but it's not true for the federal court. The federal court doesn't have to get into any of that. The only time the federal court would get into it is if the core principle of Robinson was being disregarded by criminalizing somebody for sleeping outside when they have no place to sleep inside. That's the core principle. That's the only thing the court should be enforcing, not whether people show up. And another thing I would say about the necessity defense, it may be that if the court issues an appropriate injunction in this case or another case limited to the core principle of Robinson, but it develops, or the state law develops, that there is a necessity defense, then I think that should be taken into account. And, I mean, that's in effect a time, manner, and place or similar to that. If state law comes along and establishes a realistic defense or a realistic approach to how people can remain in the community, then the courts obviously should defer to that. But we don't have that established state law at this time, and I don't think the court should decline to address this question, which is important in the Ninth Circuit, both because the principle that those courts recognize should be sustained, but the approach they've taken should not.
Last question I have on the food hypotheticals about stealing to feed yourself or cooking to feed yourself. You kind of waved all those away by, oh, that's all taken care of by local communities, nonprofits, and religious organizations. And by and large, heroic efforts each day to make sure that happens, but it doesn't always happen by any stretch.
No, it doesn't always
And then
happen,
what-
but homeless people are resourceful. They have friends who are also homeless. They may know people in town. They may beg for money. And the towns are coping in the same way, frankly, that individual homeless people do. They do the best they can under the circumstances. But that if those circumstances fail and the nonprofits, et cetera, can't, the truck doesn't show up one night, that doesn't become an Eighth Amendment problem. And we're by no means suggesting that there should be a federal judiciary overlay on top of all that. The cities and the nonprofits should be left alone to do the work that they're doing, unless the core principle of Robinson is not respected.